particularly vulnerable to sea level rise are actually potentially at risk of losing their maritime zone altogether. So that's clearly an issue which we do need to address as law of the sea scholars and indeed policymakers and lawyers. It's very much an issue which is going to be addressed within the context of UNCLOS itself. A selection of issues where you've got both UNCLOS, but more particularly it works alongside affiliated agreements, and it's also likely to be those agreements which address the issues more substantially. I'm just giving you 3 examples there. The first in relation to sort of the environmental consequences, or at least some of the environmental consequences of climate change. So UNCLOS provides for quite a number of general statements of environmental principles, general obligations to protect and preserve the marine environment, and that would certainly apply to some of the consequences associated with climate change. But for the most part, those obligations are fleshed out by other treaties or other instruments, whether they relate to shipping or regional seas or indeed sort of biodiversity protection. So UNCLOS will provide sort of basic principles, and it'll likely to work alongside these other instruments in terms of addressing some of the consequences, but clearly not all are regulated. Second example is regulation in relation to shipping. Again, that's another issue which is regulated in principle by UNCLOS. General standards, but these are added to and developed in quite a lot of detail by affiliated instruments. And as I say, the example of Arctic shipping is quite a good one there. And the third example is the sort of the selective potential climate-related uses of the ocean. So that's thinking about the ocean fertilisation, which Rosemary is going to talk a little bit more in detail, and also CO2 sequestration. So again, general principles within UNCLOS, but the detail of the regulation essentially is provided for other instruments, in this case the London Convention and Protocol. In terms of issues which are regulated outside of UNCLOS, but nevertheless have an implication for the health of the oceans, and that is emissions, or sort of the broader causes of climate change itself. There is a general provision under Article 212 of UNCLOS which relates to atmospheric pollution, a very general obligation requiring states to cooperate to take action to manage atmospheric pollution. But essentially, the work relating to CO2 emissions has been delegated to the UNFCCC. So this is a disconnect. So as we've heard from our scientists at the beginning of this panel, quite significant implications, highly significant implications of emissions, but not something which is directly regulated by UNCLOS, and very little in the way of connection between UNCLOS and the UNFCCC. And then our final category are those which are not directly regulated, and of course the obvious example here is ocean acidification. So it's not directly regulated by UNCLOS, although it is subject to general principles, and also not directly regulated at the moment by the UNFCCC. So that's an issue which really falls outside of both regimes. So it's really those 2 final categories, the not regulated and the regulated by other instruments, and to a lesser extent the third category, which are of real concern, I think, to international lawyers in terms of managing a coherent framework. So in terms of the potential ways of going forward, and there's clearly a range of options, and they're not in any way exclusive, it will be a number of options. But one option I think that we can pursue really quite quickly, and which I think would be at least effective in terms of process, is developing collaborative linkages between institutions. Now this is actually initiatives which have been taken by quite a number of multilateral environmental agreements over the last 5 to 10 years. It's actually quite an interesting phenomenon. So these multilateral environmental agreements have increasingly actually entered into quite formal collaborative arrangements, often through memoranda of understanding, with other MEAs and potentially also other bodies, in order really to create mutually supportive collaborative relationships. So it allows for greater information exchange between institutions. It also allows for the development of joint work programs to fill gaps, to develop initiatives, to provide for sort of mutual support between work programs. So just to give you a couple of examples, the Biodiversity Convention is probably the leading instrument in such initiatives. So it's actually adopted over 140 agreements with MEAs and other organisations, including universities, including non-governmental organisations. These vary. Some of them are pretty basic and are simply provide for information exchange, but others are actually much more detailed in terms of developing joint programs. Another example is the so-called chemicals cluster with the 3 chemicals conventions, the Basel, Stockholm and Rotterdam conventions. And this is actually the most advanced of those arrangements. There's a very formal structure between all 3, and they actually share institutions, so there's an issue of actually sharing resources, managing institutional resources. So I think one of the options that we can definitely think about as lawyers and policymakers in this area is developing these formal collaborations between the UNCLOS and other marine-related institutions, or marine treaties, and the UNFCCC and other institutions as appropriate, in order to begin the conversation about issues such as ocean acidification and beginning to get the oceans much more onto the climate and atmosphere agenda. So it's just a way of sort of beginning that sort of cooperation and beginning to potentially develop work programs. I think what's quite interesting, I was quite heartened to see that in the recent co-chair summary in relation to the BBNJ working group in April 2014, April this year, there's a very strong emphasis on collaboration, on cooperation, responding essentially to fragmentation through that cooperation and connection. So that certainly seems to be something which is now being considered, at least in relation to a potential implementation agreement. So I think this is probably potentially just one way forward, and one way which would support other initiatives. Thank you very much.
Thank you. Our next speaker will be Rosemary Rayfuse, who is Professor of International Law, the Faculty of Law, University of New South Wales in Australia. Professor Rayfuse researches and teaches in the area of public international law in general, and more specifically on the law of the sea and international environmental law. She's on the editorial or advisory boards of a number of international law journals and is a member of the IUCN Commission on Environmental Law. She will provide us with a short outlook on climate engineering and its regime interactions. Thank you.
At least you think that's what you're about to hear. With the greatest of respect to Disney, I loved this quote of David Freestone's in an article that he published some time ago. Despite the fact the world's oceans constitute the biggest sink of carbon dioxide and represent more than 30% of the global carbon cycle, no one has asked them to the bowl. And he was there referring to the climate change bowl, the climate change negotiations. Just by way of example, when IPCC 4 came out, the 4th assessment report came out, there was not much on the oceans in it. The 5th assessment report has very much made up for that, particularly in Working Group 2, with 2 full chapters and sections of other chapters dedicated to the oceans. I have to say the chapter on ocean systems is very interesting reading indeed. So now we have, from the IPCC, we have a great deal of evidence that tells us about just how bad things are, and they truly are bad. We know that there is a transformation of ocean systems as a result of climate change that poses very significant risks for existing marine biodiversity, for the oceans themselves, but also for the international legal regimes that have been established to govern these ocean areas. Now, Karen has already given us a description of the current international legal framework, which I think by now you will have worked out is very fragmented, incoherent, rather complicated, over and underlapping regime, which is ill-equipped, I would suggest, to respond to the challenges of spatial shifts and changes in phenology, species abundance, species interactions that are going to be caused by climate change. And we've already heard it mentioned that that's going to be particularly problematic for fisheries regimes and regional fisheries organizations. And to date, only very limited work has been done in a number of regimes related to the oceans with respect to climate change. Just to give you a quick overview, the polar bear agreement, well, they are considered a marine mammal. The polar bears agreement is in fact in danger of losing its raison d'etre. The Convention on Migratory Species has done some studies showing the high vulnerability of species listed in its appendices. The World Heritage Convention has explicitly recognized climate change as a real danger to some of the create iconic coral reefs of the world. The Convention on Biological Diversity is formally recognized the threats posed by climate change, and so on and so forth. The UN General Assembly has, of course, called for very specific studies on the topic. And to date, 6, but I have to say in parentheses, only 6, of the regional fisheries management organizations have taken what is being termed as action in respect to climate change since 1992. And by action, they mean talking about it. But one of the main problems for all of these international regimes is that it's very difficult to separate out the effects of climate change from the effects of the other stressors on the marine environment, those other stressors that we've already heard about, overfishing, pollution, etc., etc. It also is difficult because it requires functioning of governance structures across a whole range of different scales and different jurisdictions, not something that international law has to date been very well equipped to do. And the difficulties of this interaction of the legal regimes is demonstrated very, very clearly by the problem that we've heard about earlier of ocean acidification and by proposals to enhance the ocean's capacities to absorb CO2 through activities like ocean fertilization. And I talk about the problem of ocean acidification, the oceans being the victim of ocean acidification. We've already heard just how serious ocean acidification is. It poses substantial risks to the marine ecosystems, especially polar ecosystems and coral reefs that are associated with physiologic behavior of species and population dynamics, etc., etc. It also poses problems for the legal regimes that are dealing with these species. Now, where does international law fit into all of this? Well, that's where it gets difficult, because ocean acidification is not defined or specifically referred to in any binding international legal instruments. Instead, as with marine biodiversity in general, there are a number of international legal regimes that may be relevant, depending on whether the regulatory focus is the cause or the effect or both. The problem of ocean acidification has been discussed in, for example, OSPAR, and in the Commission on the Conservation of Antarctic Marine Living Resources in the Arctic Council. It's also being discussed in the CBD. But there is no regime, no singular regime focus for ocean acidification in the oceans or anywhere else. Now, given that the main driver of ocean acidification is CO2 emissions, then basically the only way to address ocean acidification, as we've heard, is to reduce our CO2 emissions. And reduction of CO2 emissions is, of course, the concern of the Framework Convention on Climate Change, the UNFCCC, and the Kyoto Protocol. But the UNFCCC is concerned with atmospheric emissions. It defines climate change, it defines emissions in the context of atmospheric emissions and the effects on the atmosphere. Now, there is a provision that talks about effects involving alterations of the physical environment or biota resulting from climate change, which can, of course, be read to include marine areas. But to date, the marine part of it has not come up in the discussions in the climate arena. And moreover, the Kyoto Protocol reinforces this atmospheric focus by suggesting that it calls for a reduction of CO2 equivalent emissions, and it doesn't talk about any effects whatsoever on the oceans. And it doesn't even talk about reducing CO2. It's to reduce CO2 equivalent emissions. So states can reduce methane or other CO2 or other greenhouse gases, but not reduce CO2, which is not going to then assist with the ocean acidification issue. Moreover, the UNFCCC actually calls for the enhancement of global sinks, the largest of which, as we know, is the oceans. And this is being read as meaning not only that parties must act to enhance the passive absorption of anthropogenic CO2 into the oceans, but that we might also act to encourage active sequestration into the oceans. And that's been taken by some as an invitation to engage in controversial marine geoengineering activities such as ocean fertilization. And where you are going to regulate these active CO2 sequestration activities is going to depend on how you characterize what is being done. And that is where we get to this notion, first and foremost, of CO2 emissions as pollution. Here's the definition of pollution from the Law of the Sea Convention. If we define these CO2, or if we characterize CO2 emissions as pollution, it opens up a whole range of possible avenues for addressing, at least in part, their effects on the ocean. The Law of the Sea Convention, of course, tells us that it's this intentional, or it's this introduction by man, directly and indirectly, of substances into the marine environment, etc., etc. It's the inherent quality of the substance that is being introduced is not what's relevant, okay? So it doesn't matter if you are introducing something that is inherently benign, if it has a polluting effect, that is what is relevant. So it may be possible to characterize the introduction either directly or indirectly of CO2 into the atmosphere, or into the oceans, which is the main driver of acidification, as pollution. And of course we know that all states have the obligation to protect and preserve the marine environment, to take measures to prevent, reduce and control pollution of the marine environment from any source. And as Karen has already mentioned, the overall framework for this is in the Law of the Sea Convention, and it is now being further detailed, the obligations set out in more detail in other treaty regimes, including the London Convention and the London Protocol, which aim to prohibit dumping at sea, unless it can be shown that the substances that are being dumped pose no threat to the marine environment. Now, where does this relate to carbon dioxide removal and geoengineering issues? Well, in 2006, the London Protocol was amended to permit sub-seabed sequestration of carbon dioxide. So it now permits certain CDR removal procedures and specific guidelines for the assessment of how this is going to be done have been adopted. But the risks of the adverse effects of ocean fertilization have been considered strong or serious enough to warrant more binding regulation ultimately. And what has happened here is, many of you in the conference are probably well aware of this. You'll know that in 2007, some commercial operators were proposing to carry out what they called ocean fertilization experiments, dumping iron into the oceans to create phytoplankton blooms to basically suck down the CO2 from the atmosphere, etc. In addition to the scientific concerns that were being raised, there were a number of legal concerns being raised at the time as to whether this activity would constitute pollution or dumping. If you go back to the definition of pollution, you could argue that it clearly constitutes pollution, but more specifically, we were fortunate enough to have a particular treaty regime in place, the dumping regime, that appeared to be applicable. Dumping being defined as the deliberate disposal of wastes or other matter from a vessel, an aircraft, or a platform, or other man-made structure at sea. But dumping does not include placement of matter for a purpose other than mere disposal, provided that such placement is not contrary to the aims of the Law of the Sea Convention. And so a number of legal issues arose. Well, is the introduction of fertilizer into the ocean, is that placement? Is iron, or is another fertilizer, is it matter? Is it being done for a purpose other than the mere disposal thereof? And are the aims of this activity contrary to the aims of the Law of the Sea Convention or the London Convention and London Protocol, which are to prevent dumping and to protect the marine environment, etc.? I'm sure you're all aware of the history of the activities in the LCLP to consider ocean fertilization. In 2007, there was a statement of concern by the scientist committee of the LCLP, and the meeting of the parties decided to take it under consideration, intending to look at the possibility of regulating ocean fertilization activities. And in a simultaneous or a parallel procedure, the Convention on Biological Diversity was also considering this and sort of jumped the gun in 2008, beat the LCLP to it, and adopted their moratorium on everything but small-scale localized experiments. And then in October 2008, the LCLP adopted first a non-binding resolution disallowing ocean fertilization except for legitimate scientific research. And then in February 2009, they started work on an assessment